Within Chapter 6, we will be discussing the legalities of ensuring a safe workplace for EMS providers. When completed with this module, you should be able to identify security issues faced by EMS personnel on the scene, during transport, and in emergency rooms of hospitals. Discuss the steps EMS personnel can take to enhance their personal safety while on the scene, during transports, and at hospital emergency rooms. Describe the risks of exposure to infectious disease and discuss the key elements of an infection control policy. Describe why Congress established OSHA and its applicability to EMS, including both public service agencies in various jurisdictions and private EMS companies. Describe the background and purpose of the Ryan White CARE Act and how the statute impacts EMS services. And discuss the workers' compensation system and the concept of an administrative system to compensate injured employees without regard to whether or not the employee was at fault when injured. To begin this chapter, consider the following scenario. You are part of a two-person crew transporting a sedated and restrained patient from your local county hospital to a hospital with psychiatric services that is more than 200 miles away. The patient has a history of violence and is currently on a 72-hour emergency protective hold at the request of the police. The crew requested a police escort, which was denied due to staffing and funding considerations. Although the originating hospital assured you that the sedation would last for the entirety of the 3-hour trip, the patient begins to wake up during the transport and you do not have any additional medications on board the ambulance to administer to this patient. As a crew, you determine the options are to stop the ambulance and call for police assistance, call the originating hospital for guidance, begin a morphine or Valium drip to calm the patient until arrival at the receiving hospital, or drive as fast as possible with the hope the patient does not fully awaken before reaching the destination hospital. Of those options, which would you consider? Before answering that question, what is your duty to the patient? What is the duty to yourself and your partner in this scenario? One of the options was to chemically sedate the patient with morphine or Valium. Is that even legal? Within the scope of this chapter, keep in mind that workplace injuries or illnesses can be either accidental or intentional. Unfortunately, violence against EMTs and paramedics is on the rise, which creates additional challenges for providers and employers. EMS providers are exposed to numerous hazards as a part of their jobs. Some hazards are easily identified, while others are somewhat more subtle. Common dangers that exist on EMS calls include ambulance crashes, physical violence, exposure to hazardous materials or infectious disease, hearing loss, stress-related injuries, both physical stress as well as emotional, injuries related to patient movement, and exposure to extreme temperature. To enhance EMS safety during the response, dispatch should assess safety information from the caller to determine if police are needed. As an EMS provider, retreating from a dangerous scene is always appropriate. Remember to constantly assess and reassess the situation for hazards. Driving an ambulance is a risky proposition, especially when doing so on an emergency basis. To prepare ambulance drivers to drive responsibly and with due regard, EMS services should provide adequate training, such as an EVOC, Emergency Vehicle Operations Course, or EVAP, Emergency Vehicle Accident Prevention Course. Remember that lights and sirens can be confusing to other drivers on the road, especially if they are distracted or have difficulty hearing your siren. As a result, ambulance drivers must always drive defensively and be prepared to take evasive action. Additionally, seat belts are mandatory even for the providers in the rear compartment, and the driver should always maintain a safe speed considering the conditions. Wisconsin Statute 346 governs the rules of the road, and 346.03 covers the applicability of those rules to authorized emergency vehicles. To begin, State Statute 340.01 sub 3 defines an emergency vehicle and includes provisions for personally owned vehicles if used by members of a fire department or rescue squad. Of note in 346 is that 346.03 sub 3 requires that both visual and audible signal be present for an emergency vehicle to be able to exceed the speed limit, proceed past a red or stop signal or stop sign after slowing down as necessary for safe operation, or disregard the direction of traffic movement or turning in specified directions. Thus, if an ambulance is involved in a crash while responding with lights on but no siren, the ambulance is not considered an emergency vehicle at that point. 346.03 sub 5 also imposes the duty to drive with due regard at all times. Reckless disregard for the safety of others is not protected under the statute. Aside from those narrow exceptions, operators of emergency vehicles are required to follow all other rules of the road. If an ambulance is involved in a crash, for instance, the vehicle must stop to exchange information and, if necessary, render assistance. If the ambulance is transporting a patient, it does not change this requirement, which means the ambulance crew will have to obtain other arrangements for the continued treatment and transport of the patient while the accident is addressed. State Statute 347.48 sub 2M requires that anyone in a vehicle with safety belts must be wearing that safety belt before the vehicle is operated. The only exception is where such use would endanger the safety of the operator or another. If you are with a fire department, Administrative Rule SPS 330.09 sub 3 and 4 provides additional clarification by stating a fire vehicle may not move until every person is seated and belted unless the person is an emergency medical specialist performing emergency medical duties. As a matter of practice, unless the EMS provider is inhibited from providing patient care by the seatbelt, he or she should be wearing it. Once on the scene of an emergency, EMS providers should assess and constantly reassess for scene safety. If a hostile situation cannot be avoided, provide a barrier or run away. Given the unknown nature of many responses, EMS providers are encouraged to be aware of their surroundings, keeping in mind potential exits or environmental features that can be used for protection if needed. While it is common to think about man-made hazards while on a scene, such as a violent patient, upset family members, or unruly bystanders, do not forget about environmental, roadway, or other hazards as well. Additional risk factors during transport include patient violence and motor vehicle collisions. Transporting or responding with lights and siren actually increases the risk of a motor vehicle collision, so drivers should always exercise due regard, which includes stopping for all red lights and stop signs before proceeding through an intersection. There is always risk of infectious disease exposure in healthcare fields, and EMS providers can be especially susceptible while functioning in the field, outside the relative safety of a hospital or other healthcare facility. Reauthorized in 2009, the Ryan White Comprehensive AIDS Resources Emergency Act, originally passed in 1990, requires each healthcare agency to have a designated infectious disease control officer. It is not the goal of this chapter on legal safety considerations to outline a full infectious disease control program. If interested in resources related to such programs, many states, in addition to the NFPA, provide educational materials related to the prevention of infectious disease transmission. The topic is also discussed further within WCTC's EMS Leadership and Management Program's Safety and Risk Management course. Continuing education, along with nutrition and exercise, all play a part in mitigating infectious disease transmission. When developing or reviewing an infectious disease program, it is important to include a description of universal precautions, the engineering and work practice controls employed, a description of mandated personal protective equipment, housekeeping requirements, biohazard control and disposal, infection control training, and immunization requirements. Not all contact with an infected patient results in an exposure, especially if universal precautions are employed. Needle stick injuries, puncture wounds, and mucous membrane exposure to patient bodily fluids, however, should always be reported so that rapid care and follow-up can be provided. Given a significant exposure, the provider should wash exposed areas, complete mandatory reporting paperwork, and be transported to a definitive healthcare facility for treatment. As an EMS agency, it is important to ensure personnel medical records are separated from routine employment records to maintain confidentiality. Employee healthcare records must also be maintained by the employer for a period of 30 years after the employee leaves the organization. A good infection control program is multifaceted and covers both high-profile elements as well as those that are often overlooked, such as the routine decontamination of EMS equipment. The control of communicable diseases within Wisconsin is covered by Chapter 252 of the Wisconsin State Statutes and Administrative Rule DHS 145. An important provision within the law is 252.15 sub 5G, which allows for HIV testing of a patient if a healthcare provider has a significant exposure while working with that patient. This statutory provision, however, only applies to HIV testing. It does not allow for involuntary testing of other infectious or communicable diseases. With that being said, the Department of Health Services does have statutory authority to monitor and take affirmative steps to prevent the spread of communicable disease. As a result, if a patient treated by an EMS crew has a communicable disease, like tuberculosis for example, the department, a local health official, or an infectious control agent from the hospital may contact the EMS agency to monitor or test the EMS providers for potential exposure. It is not possible to have a discussion about workplace safety and health without mentioning the Occupational Safety and Health Act. Enacted in 1970, the Federal Occupational Safety and Health Act established the legal requirements for employers to provide a safe and healthy workplace. The Act created the Occupational Safety and Health Administration under the U.S. Department of Labor, which sets and enforces safety and health standards for workers within the United States. OSHA also investigates workplace accidents, may issue citations for failure to comply with the law, and provides education on ways to avoid accidents. Within the auspices of OSHA regulations are the subjects of bloodborne pathogen and biohazard precautions, hearing conservation, protective clothing requirements, respiratory protection, trench rescue, and hazardous materials. OSHA also has something known as the General Duty Clause, which requires employers to keep their workplace free of serious recognized hazards. Thus, even if there is not a specific OSHA regulation that governs a particular workplace hazard, OSHA still recognizes the employer's duty to mitigate that particular hazard. While OSHA regulations have numerous provisions, one of importance is the OSHA 300 log, on which employers must document lost time injuries. This log allows state and federal governments to monitor workplace injuries and illnesses, which then allows those entities to identify specific trends in workplace injuries with the goal of reducing such incidents in the future. Whether OSHA applies to your EMS agency actually depends on a few things. First and foremost, OSHA does not apply to the federal government or state governments, including political subdivisions of the state. This means that an EMS agency owned and operated by a governmental agency is not automatically governed by OSHA. A private ambulance company, on the other hand, falls under OSHA authority. Each state is responsible for regulating governmental employees' safety and health within their own state. Because federal monies are available, many states have filed OSHA-approved plans whereby the state legally adopts and enforces OSHA regulations for public governmental employees. As of the date this presentation was prepared, there are 28 states or territories that have OSHA-approved plans in place. Within the Midwest, this includes Illinois, Minnesota, Indiana, Michigan, and Iowa. Notably missing from the list is Wisconsin. Public employee safety and health in Wisconsin is governed by the Department of Safety and Professional Services and Administrative Rule SPS 332. There is also a rule specifically written to govern fire department safety and health, SPS 330. Despite these standalone regulations within Wisconsin, the majority of OSHA provisions still apply as Wisconsin incorporates most of the OSHA regulations by reference. Also related to workplace safety and health is the workers' compensation system. Workers' compensation is a state-regulated system that provides injured workers with medical care, income, and survivor benefits if an employee is injured or killed while at work. Before workers' compensation laws existed, an employee who was injured at work had to sue the employer to recover medical expenses, lost wages, or other damages related to the injury. This process was lengthy, expensive, and oftentimes favored the employer. On the other hand, the system also included a significant amount of expense and uncertainty for the employer, as lawsuits can be costly and a legal award of damages could exceed the employer's expectations. With these factors in mind, workers' compensation systems were developed as a compromise for the sake of all parties. When an individual is injured during his or her employment, the employer is strictly liable for the costs associated with those injuries. The concession on the other side of the coin is that the employee is not entitled to sue the employer unless gross negligence on the part of the employer was involved. Within Wisconsin, workers' compensation is governed by State Statute 102. All employers in the state with 3 or more employees, as well as any governmental entities, are required to have workers' compensation insurance. Of particular interest is 102.03 sub 1C2, which recognizes volunteer firefighters, first responders, emergency medical technicians, rescue squad members, and diving team members as performing functions growing out of and incidental to employment while responding to a call for assistance from the time of the call for assistance to the time of his or return from responding to the call, including traveling to and from any place to respond to and return from that call. If qualified for workers' compensation benefits, the employee will receive coverage of all reasonable and necessary medical expenses, along with benefits for temporary wage loss during the healing period. If the employee is permanently disabled, either partially or totally, additional benefits are available. Vocational rehabilitation and retraining benefits may be available. If a death occurs, death benefits and burial expenses may be paid to the beneficiaries up to specific limits. EMS employers are required to pay for and maintain workers' compensation insurance. As claims against the agency's workers' compensation insurance could potentially impact its premiums, it would be in your best financial interest as an EMS leader-manager to foster a safe and healthy work environment. Premium costs are also governed by the risk associated with the specific industry in which the employer participates, along with the payroll maintained by the employer. High-risk industries have higher premiums. As discussed earlier, the Ryan White Care Act has provisions that apply to EMS in that receiving hospitals must provide reports to EMS agencies in the event of a suspected exposure to a patient with a communicable disease. In order to receive such information, the Emergency Response Agency must have a designated infection control officer to field those calls and obtain the disease status of source patients. Additionally, at the federal level, the Centers for Disease Control and National Institute for Occupational Safety and Health share information about potential exposure with EMS providers and other emergency service workers, such as police officers and firefighters. One of the benefits of the Ryan White Care Act for EMS is in Part G of the law, which provides for the notification of emergency response employees who may have been exposed by victims of emergencies to potentially life-threatening diseases, such as anthrax, Ebola, hepatitis, HIV, and tuberculosis, to name a few. Under the Ryan White Care Act, an EMS agency's infection control officer must respond to requests from EMS personnel to evaluate an exposure, obtain and evaluate information about potential exposure incidents, forward requests to the appropriate medical facility if there is suspicion of an exposure, and communicate information regarding such an exposure from the medical facility that made the determination to the EMS provider within 48 hours. With the information provided in this chapter, it is now time to reflect on the starting scenario. To begin, the transport should have been declined until adequate staffing from law enforcement was available to accompany the ambulance. Assuming this did not happen, the next thing the crew should have done during the transport was to contact the base station for permission to administer sedative drugs, assuming those medications are within the scope of practice for the providers. If such medical control was not available and chemical restraint is an approved protocol, the crew should have administered those medications and followed their local protocols regarding the failure to contact medical control. After the patient is controlled, continuing the transport to the distant medical facility should be discontinued and the crew should transport to the closest facility, possibly after consultation with the transferring facility. If the patient awakens and there is a danger to the crew, the police should be summoned immediately. Ultimately, EMS providers do not have to place themselves in harm's way to treat combative or abusive patients. Provider safety must be of the utmost priority for the benefit of everyone involved. In conclusion, safety must be the most important factor in all elements of patient response, treatment, and transport. Personnel must be knowledgeable about laws and policies related to driver safety, infectious disease prevention, self-defense, and workplace injury prevention. In the event of an injury, EMS providers, leaders, and managers should understand workers' compensation provisions in their respective state. It is also important to be aware of the Ryan White Care Act and what actions employers must take to comply with the law.